Good afternoon, everybody, on this beautiful, sunny, warm day. I hope you are really well and keeping cool. I'm Lottie, founder of the Juror Society. We bring women wealth holders and their advisors together through our education, connection, and collaboration across our three pillars of women, wealth, and well-being. This afternoon, I am joined by Amy Rowe, a leading family lawyer and partner at Hunter Law, for a deep dive into legal aspects of contemporary motherhood, from co-parenting frameworks to the realities of donor conception and surrogacy, both in the UK and internationally. Please note this is for education purposes only, and if you do have any questions, do feel free to ask them in the chat or reach out to myself or Amy directly. So let me just get Amy in now, and we will start this very important discussion. Hi, Amy. How are you?
Hi, Lottie. I'm good. Thank you very much. Thank you for having me today on the Essential Series.
You're so welcome. And I think this is a topic that is very much in the sort of press. There's a lot of discussion about it, and it's a really, really important one that you are the expert on. So I'm really excited to pick your brain and ask you some of these really telling questions. So before we kick off, though, would love to ask you how you got into what you're doing and why you do it.
I sort of got into it by a happy accident. I was training at a firm and thought I wanted to do a different area of law, and then I did a family law seat and loved it. And so I practice across the whole area of family law, including alternative family formation, and it's just wonderful helping people build their families. I also am a mum of two children that I had through IVF. So I understand the longing to become a parent and the difficulties that can be encountered. And so it's a real joy and privilege to help people to overcome those challenges.
Yeah. And if people recall, earlier, was it early this year or late last year? I can't even remember. We were sat down together for an in-person conversation all about this, and I think that was a really, really powerful discussion. I know that everyone came away with sort of either a sigh of relief or some real good action points to take them into what can be quite challenging, especially as you say, that longing for parenthood. But before we go on to sort of the surrogacy and the IVF, let's just start with co-parenting, because you may already be a parent. And what legal structures are there that people should consider when planning to parent outside a romantic relationship?
So I think if planning a sort of a known donation arrangement, it's really important to set strong foundations from the outset, and to take time to explore the options and ensure that relationships are strong enough to withstand disagreements. I think disputes, when we see disputes arise and then court proceedings unfortunately take place following a known co-parenting agreement or arrangement breaking down, the disputes very commonly stem from underlying mismatched expectations. So it's really important to take time to discuss the roles that each person intends to have, and to carefully consider who will be the legal parents, stress test all eventualities, talk about things like parenting philosophies, discipline, screen time, diet, sleep, expectations around roles, what will you each be called, daily logistics, involvement of any current partners, future partners, wider family members, will you live together, nearby, long distance, what time will the child spend with each of you, how will you decide schooling, religious upbringing, and a big bone of contention is often finances. How will you divide ongoing financial responsibility? And I think it's really important to be really clear at the outset and honest with yourself and the other person at the outset, to ensure you're aligned on your views.
Yeah,
forward.
I think it's, all parents should really have these sort of discussions beforehand, didn't they? But it's not something that you necessarily either feel like you can bring up, because these are heavy questions as well. And people might just not know the answers to it, or they may feel awkward, or they might be fearful of misalignment. But actually, all you say is so valid, whether or not you are possibly going into a sperm donor arrangement with, say, a friend, and then it's what will that outcome look like. So so important to get that that groundwork and lay the
Mm-hmm.
land before you get started, because as you say, mismatched expectations are usually at the bone of contention for any relationship.
Yeah.
Or just life in general. As humans, expectation management is key. But how do these legal agreements help to manage them and to protect parties? So when it's a friendship, not a partnership, what might they look like, and how could you enforce them, let's say?
But I think it's really important to note that co-parenting and preconception agreements are not legally binding. So they're really important documents to help stress test the arrangement and set out intentions. But if the arrangement breaks down, it won't be legally binding. So it's still worth entering into these arrangements, because in doing so, you have to have these discussions, and it makes pause for thought for both parties. And it also provides a really important written document of both parties' intentions. And they do carry weight if there's a dispute, particularly if both parties have had legal advice, and that hold greater weight. But if there is a dispute at a later stage, the family court will pay attention to what the joint intentions were, but it's not obliged to follow the agreement if the court thinks that another arrangement is in the child's best interests. And case law is very variable. So the outcome in these sorts of situations is varied enormously, depending on the facts of each case. And there are some cases where you'll just have identity contact ordered at the end of proceedings, where a child just sees the donor once or twice a year, so they know who the biological parent is, to very regular arrangements, sometimes shared care. So if parties want more certainty, it is possible when the child is born to apply to have an agreement turned into a consent order. So that's a court order. So you can turn it into an order and apply to court for that to be sealed and approved by consent. But I think, again, it's important to note that orders can be varied. Children change as they grow up, and what's in their best interest may change. And so it's possible to go back and revisit if there are grounds for doing so. So it's never possible to freeze arrangements with, an agreement that's been entered into ahead of a child being born.
And on that note as well, just something that just popped into my brain. Do the children ever have any influence on, or consideration on these arrangements? So, maybe they're past a certain age. Would the parents or the lawyers sort of bring them into the conversation and say, what would you like?
Absolutely. When deciding what's in a child's best interest, the court looks at something called the welfare checklist. And one of the factors is the child's wishes and feelings. So the older a child gets, the more their wishes and feelings are taken into account and the more weight they are given. Now, before heading to court, there are lots of routes to try and reach an agreement. And one is mediation, and it's possible to have child inclusive mediation. So the mediator speaks to the child. And then if you go to court, a CAFCAS officer, a court and family welfare officer, will always speak to the child if they're above a certain age, usually about 5. So their wishes and feelings will be included in a report and known to the court. So they will be part of the process. I mean, their wishes and feelings won't be determinative, but as they get older, of course, they more often than not are, because with teenage children it's very difficult to make them do something they don't want to do.
Yeah, and sometimes perhaps they don't know what's in their own best interest necessarily at that point. No, that's really helpful. Thank you for clarifying. And again, let's go down to key legal distinctions then between known and anonymous donors. We mentioned before about, whether or not they wanted to see their biological parent. What are the key legal distinctions between that?
So I think the key legal distinction between a known donor and an anonymous donor is legal parentage. And so a legal parent can be named on the birth certificate and may also be liable for financial claims, so child maintenance and Inheritance Act claims at a later date on death. So if you go down the known donor route, if a child is conceived via intercourse, then the father, the biological father, will always be the legal parent, irrespective of whether they're named on the birth certificate. If there is artificial insemination, and if the birth mother is married and her partner doesn't consent, or if she's not married, then the donor will be considered the child's legal parent. And the donor can then also acquire parental responsibility for the child if they're registered on the birth certificate or if they apply to court. And so parental responsibility is the rights to make important decisions like where a child goes to school, medical treatment, removal from the country, what time they spend with each parent. So a known donor may inadvertently end up with responsibilities that they don't want. And a mother may inadvertently end up with a donor who has more rights and responsibilities than they had hoped for. So it is important to really think about whether you want a known donor or an anonymous donor. Now, a known sperm donor can avoid legal parentage if they donate through a UK licensed fertility clinic and sign the correct forms. And if they do that, they won't be the legal parent, they won't have parental responsibility, and no financial claims can be made against them. So that's a route that can be gone down to avoid becoming a legal parent. Whereas if someone uses an anonymous donor from a clinic or a sperm bank, then the donor will not be the legal parent. They won't have parental responsibility. They won't have any legal financial responsibility towards the child. They won't be named on the birth certificate. So it's a very different outcome, potentially, depending on which route somebody goes down. And so it's very important to think about what involvement and responsibility you want the donor to have, and for the donor to also think about that.
And is it possible to do any variations on this? So say later down the line, if somebody changes their mind, can you sort of opt in or opt out of that responsibility? How does that work in terms of time horizons?
I think it's not possible to opt in or out if you've gone down the anonymous donor route. That's, you know, if you go down the known donor route, then if someone isn't named on the birth certificate, they can try and opt in at a later date and apply to court to be acknowledged as a legal parent and have parental responsibility and contact. If they go through the clinic route and they're not the legal parent, it's difficult to do that. They can apply for permission to court to try and have contact with the child, and that will be dealt with on a best interest assessment. Whereas if you go down the anonymous donor route, they can't find identifying information about the child. So it's hard for them to come back and opt in. You know, it's not possible now to donate egg, sperm, embryos anonymously. So once a child reaches 18, they can find out the donor's name and last known address, but the donor can't contact them.
Okay, so one way.
One way, yeah.
Okay, that's really interesting to know. And so I guess as we're on this subject, what are the main considerations that you would point out for individuals or couples using international sperm or egg banks?
Well, I mean, a reason why a lot of people will go abroad is for donor exclusivity. So in this country, a donor sperm can be used to create 10 families. With no limit on the number of children per family. And then a donor may also have their own children. They may have donated outside of a clinic. So you can end up with a number of half siblings. And some people want to avoid that and to have donor exclusivity. And that's usually a driving factor to go abroad. But I think whatever the reason for going abroad, it's really important to take advice in that jurisdiction, in this jurisdiction, and to really ensure that you do research. And that's research into laws, parentage laws, who will be the legal parent, because that can differ in different countries. Donor anonymity. In some countries, they require open identity donors, and in other countries it can be anonymous. So that impacts on the genetic information that's available to the child. So it's important to research that and know what you're dealing with. It's important to look into import and export laws, because transporting gametes across borders is regulated. So you need to comply with the laws in both countries. It's really important to look at screening standards and make sure the bank or the clinic adheres to high medical screening standards for infectious diseases, genetic conditions, general health. Important to look at success rates at the bank or the clinic, you know, fertilization, implantation, live birth rates. And from an ethical perspective, it's really important to look at consent and informed consent. really make sure that donors are giving informed consent, particularly in countries where economic disparities may influence their participation in donating. Look at donor limits, as I said, how many births per donor are allowed. And then I think something really important to look at is costs and cost transparency. Make sure you know exactly all the costs that are involved, for donor compensation, screening, legal fees, shipping, storage, medical procedures, and that you're not going to get a load of add-ons that you weren't expecting.
Yeah. Well, come to you as well. I think that's the starting point, because it seems like early. But let's come back to the UK. What does that legal process look like for obtaining parental rights through surrogacy arrangements?
So in England, we have a bit of a clunky procedure, which is long overdue reform, but in a surrogacy arrangement, the surrogate mother is regarded as the legal parent, and this applies irrespective of whether she's genetically related to the child. And if she's married, her husband will be the legal parent as well, the legal father, and they will be named on the birth certificate at birth. So the intended
husband, sorry, cutting you in. So the husband would be legal parent even if it's not his
child.
genetic.
Absolutely.
Okay, interesting.
Absolutely.
Okay,
so a lot of people will opt for a single surrogate if they can, to avoid the issue of double consent being needed.
Okay.
And also then the other parent can then, in circumstances, be named on the birth certificate as well. So there's an added protection there.
Okay.
But the intended parents, irrespective, will need to apply for a parental order to be recognised as a legal parents. And the earliest they can do that is 6 weeks after the birth of the child, because the surrogate has to be given a cooling off period to make sure they're giving free and informed consent. And then once made, the parental order extinguishes the birth mother, and if she's married, her husband's status as the legal parents, and the intended parents will be recognised as the child's legal parents from birth. So that process is it can cause real anxiety for intended parents, that you have to wait for the surrogate to consent and go through that process post birth. And there's also a number of requirements that you have to be able to fulfill. So it's really important to get legal advice ahead of going through the process, because for the court to make a parental order, you've got to comply with the child's got to be carried by a woman who's not an intended parent, and she has to have had placed in her the egg, sperm or embryo which contains the gametes of at least one of the intended parents. So at least one of the intended parents has to be genetically related to the child. So I've had cases where people have come and they've had surrogacy in different countries and neither of them is genetically related to the child, and that's not permitted within our regime. The application's got to be made within 6 months of the birth of the child, although the court has relaxed that timescale in some cases. And the child's home has got to be with the intended parents at the time of making the application. At least one of the intended parents has got to be domiciled in England. So that's a legal test that it's important to get advice on. And also the surrogate cannot have received money other than reasonable expenses, and that is because commercial surrogacy is not allowed in this country. So although I think it's fair to say reasonable expenses form quite a wide band, and people do go abroad and enter into commercial surrogacy arrangements, so the courts do take a fairly relaxed approach to that. But all the same, it's important to have advice to make sure that you haven't, paid some crazy sums that may end up falling foul of that legal test.
That's really helpful. Thank you, Amy. A question's just popped up here saying, are these issues regarding parenting discussed in prenuptial agreements for couples?
They're not routinely, and there has been, you can enter into a parenting plan or a parenting agreement.
Mhm.
I think it's fair to say very few couples that come to us do. I think, when people enter into prenuptial agreements, they generally think that everything's good and they're going to be aligned on all of these issues. And I think it's fair to say that married couples spend less time thinking about whether they're aligned on how they're going to bring up children before embarking on the process than a lot of couples who enter into families through these alternative routes. So it is possible to talk about it and to have it scheduled to a prenup or to have a parenting agreement. But, I think in practice, very few people do it.
Cool. Thank you. Hope that helped. Right. So we've talked about the UK, but there are different experiences for those looking internationally, like for the likes of the US, Ukraine, or Georgia. What should intended parents know in advance if you are pursuing surrogacy? I mean, why don't we focus on the US perhaps? Do you think that's what the differences might be there?
Yeah, I mean, I think actually, most people choose to go abroad to countries where commercial surrogacy is allowed. And in those countries, commercial surrogacy is allowed because there's a greater availability of surrogates because they're being reimbursed at commercial rates. And there's also greater legal certainty because contracts are enforceable and or intended parents obtain legal parentage from birth. So that's, really attractive to parents not to have that level of uncertainty. More people choose to go to the US than Ukraine or Georgia because surrogacy is available for same-sex couples and single parents, which it isn't in the other two countries. So really important if you're thinking of embarking on surrogacy abroad that you look at whether you fall within the permitted routes. But I think, it's really important wherever you go to ensure that you undertake research on the clinic and it's a reputable clinic. And I think one thing that people really need to know in advance is that they need immigration advice as well as family law advice. Because whilst you may be a British citizen and your partner may be a British citizen and it may be both of your gametes, it doesn't necessarily follow that the child will automatically have immigration status or British citizenship or be able to get a passport, even if they've got a passport from the other country, because you've got a birth certificate in that country. So it may be possible to bring them in on that passport, but it's just really important to get immigration advice so that you can achieve the quickest route to return to the UK. And it's also really important to note that whether the child is born in the UK or elsewhere, a parental order is still required. So even if the surrogacy took place abroad and the intended parents are named on the birth certificate and they're the legal parents in that country, they still have to apply for a parental order in this country to be recognised as the legal parents in this country and to have parental responsibility and all of those parental rights in this country. So it's I've had cases where people have got quite grown-up children and haven't realised they've needed to go through that process until there's been another legal issue, and I've said, oh, hang on a second, you're not the legal parents in England. We need to get a parental order.
It's amazing that it's the unknown unknowns, I think, as well. If you're doing something in a different jurisdiction until you come over here, you would just be like, there's not a warning sign that flaps up until there's a problem. But going back to that legal process, typically, how long does it take, and what would you say are the key milestones? And I guess there will be different ones depending on whether it is surrogacy or IVF, won't there?
I think, it's easy to surrogacy. The process takes about 6 to 12 months to get your parental order following the child being born. And so that, you'd wait 6 weeks, you'd submit your application to court, and you'd need to submit the birth certificate and a marriage certificate if applicable, and the surrogate's consent on the prescribed form. The court will issue the application, and then the intended parents will need to file a witness statement showing how they comply with the various legal requirements. A CAFCAS officer will be directed to prepare a report on whether the order's in the child's best interests, and safeguarding checks will be done to make sure that the intended parents aren't known to the police or the local authority, or there's any risks. And then there may be 2 hearings, a directions hearing and a final hearing, or if everything's in order, it will proceed straight to a final hearing. And so in a straightforward case, that whole process is 6 to 12 months. And then other cases, you know, if you want to turn a parenting agreement into a consent order, that process can take about sort of 6 months, depending where you are in the country, because, you know, court delays in London are quite quite extreme actually. But you issue your application, you ask for it to be dealt with on paper, often they'll list a hearing, but it will be dealt with at that first hearing. So that process will take about 4 to 6 months. And yeah, I mean, other processes in terms of, you know, going down the IVF route, it's sort of, you know, it can be as quick or as painfully long as it takes, depending on the circumstances. It's and depending on, you know, what treatment is required.
Yeah, definitely. Oh, that's really interesting. And I guess, you know, following on from that, what advice would you give to someone who is beginning to explore these options, whether it is co-parenting, say with a friend, with a donation, or, you know, anonymous donation, or surrogacy? What are your, you know, the top tips for a beginner?
I think sort of starting the journey to parenthood can feel overwhelming, and each path is deeply personal, and the right choice depends on one's goals and life circumstances. And I think it's important to understand what each path involves, because each has its unique legal, emotional, and logistical implications. So I think early legal advice and early research on each option is essential before deciding and embarking on the process. I think it's really important to use reputable clinics and resources. You know, reputable clinics will provide responsible advice and treatment options and paths. They'll make sure the proper forms are completed so that problems don't arise later down the line. And, you know, proper resources will contain, you know, responsible and correct education information. There's some great resources around. I think, you know, look for online communities or support groups to hear lived experiences, you know, find out. It's always good to hear other people's experiences. And hear about, you know, the sort of the successes, the pitfalls, the, you know, potential problems. I think if you're going for a sort of a known donor co-parenting arrangement, it's really important to consider who will be the legal parents in any arrangement. How much involvement do you want that other person to have? Do you want them to be a parent? Do you want them to be involved or not? Because that will really inform what kind of donor route you go down. Crucial to take time to explore options and ensure relationships are strong enough to withstand disagreements. And, you know, ensure that expectations are clearly communicated. And then I think one thing people really underestimate is that it's really important to prepare emotionally. So talk to a therapist or a counsellor who has experience in alternative family building, because emotional readiness is just as important as legal, practical, and financial preparation when going down this journey.
Yeah. Oh, you spot on. Absolutely spot on. And you mentioned resources. Are there any that you might be able to share in terms of networks, organisation, for anyone who is navigating this space?
Yeah, there's lots of good resources. I mean, I think it's important to sort of flag that if embarking on surrogacy, it's a criminal offence for anyone to advertise that they're looking for a surrogate or willing to act as a surrogate. It's a criminal offence for third parties to advertise that they facilitate surrogacy, and it's a criminal offence for third parties to negotiate the terms of a surrogacy arrangement for payment. So that is a minefield, but there are a number of non-profit organisations that can assist potential surrogates and intended parents to find each other and navigate their journey. And they also help ensure that people, you know, have counselling and are matched, and that they have a certain amount of time with the surrogate before they embark on the process. So some good organisations are Surrogacy UK, Brilliant Beginnings, My Surrogacy Journey. They've all got good websites. And I think they might also provide information about surrogacy abroad if that route's been considered. If you're going down the donor conceived route, then the Donor Conception Network is great. They've got a good website, and they offer support, information, and a community of families in a similar situation for donor conceived families. And there's also a good list of resources and links on their website. The British Infertility Counselling Association has a list of fertility counsellors with experience to make sure you're emotionally ready and have that support. There is the Fertility Network UK, which offers information, support groups, and webinars and counselling. And then Pride Angel is a platform for finding known donors or co-parents. So that website also has educational resources and legal guidance, but it also helps to match people who want a known donor. So I'm sure there's, I think, lots of other good sites that I've forgotten there. A good number to be getting on with, and they've also got good links and to other resources as well on their websites.
Well, that's excellent. And I suppose I have to mention our fantastic committee member, the wonderful Zita West, who is the IVF champion with amazing success rates as well through her approach. So yeah, if anyone needs to see that,
I had my children with Zita West, and they're great because they're really holistic, and so they really focus on nutrition and mental well-being, acupuncture, all of sort of a holistic approach to fertility rather than a really medicalized. Yeah.
And it works.
It does.
Because we're all humans, and you are the proof in that. Thank you so much for all of this. Before I let you go, what crystal ball gazing, looking to the future, what do you think family formations are going to look like in the next 10 to 15 years, both legally and culturally? It looks like there's a lot of reform required for surrogacy, for instance, but in your words, what do you anticipate?
I think, well, law reform can be slow in England. And as diverse paths to parenthood become increasingly common, the law is going to be under pressure to catch up. And, I really hope that there will be reform to surrogacy law. It's under review. The Law Commission has done a report. We just need the government to have the appetite to make the changes. And one of those recommended changes is that intended parents are named on the birth certificate and are the legal parent from birth. And I think that's a really important and necessary change. So I hope that will happen in the next 10 to 15 years. I think, as co-parenting families become more common, it would be interesting to see if legal reform would allow for more than two legal parents, where you have two couples, embarking on a parenting journey. It may be, same-sex female couple and a same-sex male couple. It'd be interesting to see if, all four parents can be recognised as a legal parent. I think I really, really hope there will be improved workplace policies to allow time off for fertility treatment and appointments. And, these routes can be very expensive. And, I hope that there will be better fertility benefits and insurance policies. And some companies are doing it, some bigger companies, but it would just be great if across the board there could be better financial policies for people to enable them to embark on this process and have much dreamed of family. But I think increasing cultural normalization around alternative paths to parenthood is already happening, and I think the stigma associated with solo parenting or donor using a donor or a surrogate is diminishing, and I very much hope that will continue to diminish, so that these routes to parenthood are more accessible, and that there's I hope there'll be a continuing cultural shift towards celebrating and accepting non-traditional families, so more people can realize their dream of becoming a parent.
Yeah. Wonderful and beautiful ending to that. And thank you so much. Yeah. And I think, yeah, love is love. And it's you know, we sadly just missed Pride, the end of Pride month. But, you know, I think opening access to parenthood for those who wish to be parents is so important as well. Yeah. You know, it's an amazing thing. So thank you so much, Amy, for sharing all of your wisdom. And thank you to everybody for either tuning in live or if you're following us on the replay, hello. And if you do have any questions you'd like to follow up, do, as I mentioned, reach out to myself or Amy directly, or I'll put you in touch with Amy. And yeah, thank you again, Amy Rowe at Hunter's Law, for sharing all of your information with us. So yeah, here's to happy families.
Yes. Thank you, Lottie.
Thank you. See you soon. Take care.
See you. Bye.
Bye-bye.